Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, everybody. I hope everybody's doing well today. Thanks for giving me my extra minute to grab my Coca-Cola. It's going to be ice cold in a minute. Oh, you can't quite see in there. But that's the plan, ladies and gentlemen. I hope everybody's doing well today. I would love to hear what you had for dinner. If you didn't like what you had for dinner, go ahead and tell me what you wish you had for dinner. I haven't had dinner yet. I was going to make a sort of Mexican-inspired taco night, but there was no tortilla chips available. And it's like one of those things that I sort of need when I make that meal. So I guess we'll see what happens. I did have my first experience with having the wrong item for my Walmart order yesterday after I walked and picked it up. They gave me the wrong peaches. I don't know why I put air quotes around peaches. They're absolutely peaches, not fake. But they gave me one pack that was packed in strawberry jelly, which I didn't order. And I know that they had to I'm grabbing them. I know that they had to scan the right ones or else it wouldn't have let them do it. I don't get it, why they would give me these. The peaches, diced peaches in strawberry flavored gel. I'm sorry, no, they're so red. I have a funny feeling these are gonna stay in my house as food that you don't eat but that lives there. I love the peaches in water. It's sort of like my dessert treat. I have the peach cups, and that's when I'm getting a bit of a sweet tooth late at night. I just grab a fruit cup and eat that, and that's been pretty good for me lately. I felt like that's a good option. So I ordered 2 packs. And then they sent me this fucking bullshit. Plus side, the refund process seemed to be easy on the Walmart website. Negative side, instead of refunding me money, they charged me more money. I'm baffled at that. I don't know why. I don't even know how to figure that out. So I'm not sure if they want these back. No, it looks like Jell-O. It looks like Jell-O. Things are suspended in there. Something's suspended. Taking all my good light. So I'm not sure if they will want them back or what. And then this morning, as I was planning out tonight's dinner, I picked up the taco seasoning, and I read it and I said, mild? Bitch, I did not ask for mild taco seasoning. So I waddle off to my computer because now that I know how to do a refund request, I'm like, well, I'll just do that again. But I double checked first. I was like, you better check to make sure what you ordered, Paisley. And I looked, and indeed I did order mild taco seasoning. So I didn't return that one. That one's on me. But I definitely didn't order these. I 1000% know I didn't order these. Yeah. I don't know. The strawberry jelly does not appeal to me. I had an incident as a child with Jell-O like being fed Jello when I was sick as a child, and then being overfed Jello when I was sick as a child, and then Jello, and just not enjoying it again. Like, that's the occasional one singular piece of Jello at a buffet I've been known to partake in once in a while. I would say Jello I eat even less frequently than hot dogs, which I eat very infrequently. Maybe one every 2 years or so. Anyways, that's my Walmart dilemma from last night. 3 miles I walked to get the wrong peaches. No, I picked up all my other groceries as well. So, Mayor, you are indeed in the right spot. Thank you for being here. You too, Grizzly Little Fart. I did make a thumbnail today for this video because we are indeed watching Judge Kirkham. I don't know what it's about. Yes. Yes. But, oh, let me have a sip of my Coke. First sip is always the best. Little ice chunks. I like that. Ooh, okay. So, Judge Kirkham, that's who it is. That's who it is. Anyways, I have so much court that we got today that we're going to have to look through, either me later or... They're not Jella? They're not jelly? But it says jelly. It says in strawberry flavored gel. Okay, you can't see it. There. I promise you. It says in strawberry flavored gel. Spelled J or G-E-L. G-E-L. I'm pretty sure it's Jello or no name brand. Gelatin gel. Whatever you would call it. No name brand. Oh, we have a question now. We have a quick question here. Because can't both be. Because they did give me one correct package of peaches here. And this is in fruit juice. I don't think that's what I ordered either, but okay, so 30 calories of gel. 30 calories of gel. I have to say I've become a great value girl because I don't have any money. And so beggars can't be choosers when the price is almost the same. Like cheese, for example, I actually don't mind the great value cheese. But I get it. I never thought I would be an off-brand lady, but here we are. All right, so we're going to Judge Kirkham today. Do we think he's an off-brand judgy? I don't think he is. I don't think most judges are. I think they get the name brand. Here's the thing. Certain things, name brand, I understand getting as the name brand. Specifically, like I still get Pillsbury stuff, but even more, we have a store here called Save On Foods. I don't know if you have that in the States, but they have a very good house brand, they call it, called Western Family. And I had one of their employees tell me, he's like, it is the exact same stuff. We buy like the oliveri pasta and they just white label it. And it's true. I've tasted a lot of their stuff as well. And the white label brand is almost as good as the store brand is almost as good, if not the exact same as the regular brand that they're using. Oh, here we go, Judge. Here we go.
9th, 2024 at 10:08 a.m.
Mr. Brown, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, I do.
I advise you have a right to an attorney. The court will appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes, sir.
Are you doing so freely and voluntarily?
Yes, sir.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No, sir.
Okay, thank you. What we're going to do, Mr. Brown, we're going to take some testimony. So I'll have you and Ms. Platic raise your right hands. We'll have you sworn in, and we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Go ahead, Ms. Platic.
Thank you, Judge. We're here on docket 2009-4122 DP in the matter of Daniels versus Brown. Joseph Brown is the respondent in this matter, appearing for a bench warrant after he failed to appear on December 29th, 2021 for an adjourned show cause before your honor. This is the fifth bench warrant in this case with 2 prior show causes and 1 finding of contempt. Presently, he should be paying $152 per month. That's $99 in current support. Guideline obligation on arrears of $49.50 plus the service and processing fees. Compliance was measured over 12 months at that $152 per month. During that time, he made no payments, leaving him short for the year $1,824. Last payment made in this docket was on May 27th of 2022 for $41.26 that was collected through Interstate with Ohio. Current arrearage in this matter is $6,993.29 through the end of April. There have been no prior jail sentences, and he booked into Calhoun County Jail on May 19th of 2024.
Is the judge like shaking, or is he like tapping his computer desk? What's going on with his camera? Also, when I went to Aldi in the States, I was amazed and saddened. Actually, almost every grocery store, even Publix, which I'm to understand is expensive, I found cheap compared to grocery shopping here. Like, for example, my roommate, dumbass that he is, I don't drink milk very much. I drink a lot of cream for coffee, but I don't drink milk. But they go through so much milk, so he buys the milk, and I offered to buy the milk at Walmart because it's like $5.45 per gallon, and then he didn't want the milk, so he went and got it himself at a different store, and it was $8 a gallon for the exact same milk. Exact same milk. It's crazy to me. It's craziness. And that's not even buying like the organic milk. You can buy organic, like top of the line milk here for like in glass jars for $15, $16 for like 2 pints. It's nuts. That's a lot of people. Like really bougie people around here that like getting their milk in a glass jar. I find that crazy.
Okay. Mr. Brown, do you dispute or contest any of the statements made by Ms. Platic?
No.
Do you have any questions for Ms. Platic?
No, I do not.
Okay. Mr. Brown, what would you like to tell me? What's happening? Why have you not made any payments in over 2 years now?
My mom got diagnosed with a small cell lung.
Sorry, buddy. Sorry to cut you off there. We were just going to get our excuse counter reset because we're sure you'll have a few of them. No offense. Not trying to be rude. Yeah, there we go. We're at 0. Let's go ahead and use our excuse counter. I think he just said his mom got diagnosed with something. That's a 1. And let's continue.
Cancer. And I was the only one that was able to take care of her. So I had to quit working so I could care for my dying mother.
Okay.
Oh, I'm a terrible person. I laughed so hard at that. I mean, he's at 3, but I laughed at his attempt there to sway the judge with my dying mother comment. Sir, how long has she been dying? No offense, but you know,
And did your mother pass?
Yes, she did.
And when was that?
November 16th,
Of 2023?
2024.
Well, we're not to 2024 yet, so.
Or, yeah, 2023. My bad.
Okay. Tell me, what have you done since that date, November 16th, 2023, to acquire employment?
I have come back here to Battle Creek. I just came back here the 17th. And I was working with the Sheriff Center with Matt Jones, as he's the peer support down there. He was helping me try to get my ID and my birth certificate up here so I can get employment up here. Because all my stuff got stolen when I first got up here.
Okay, what's your education background, sir?
9th grade.
Have you taken anything towards your GED or done anything in that regard?
No, I have not.
And is there a reason that you haven't done that?
Because I can't read.
Is there anything you've done to work on that? Trying to get yourself where you could read and then you.
Yes, I'm working with some people at the Sheriff Center, and they're helping me with my grief counseling and they're trying to teach me to read. Yes.
Okay. When did you start working with the Sheriff Center?
When I first got up here on the 15th.
15th of what?
May. I've only been up here just a few days.
Okay.
I'm trying to get into the MLRP for the Men's Life Recovery Program. I'm trying to get into that for help.
Okay. Aside from working with, well, you were only here a few days before you got picked up. Is that correct?
Yes.
Between the time of your mother's death on November 16th through the time you got up here and got on the 15th, you were in a different state. What did you do in that state to acquire employment?
I was a meth addict, you know. When my mom got diagnosed with small cell lung cancer, I took to sticking a needle in my arm and getting high.
Did that accomplish anything?
No, it just sent me back even farther and made more problems for me now.
Okay. Anything else that you'd like me to be aware of, sir?
I'm like I said, I'm just wanting to go into the MLRP and get my life straightened back out.
Okay.
I'm trying my hardest just to get my life straightened back out.
Okay. Well, thank you for your testimony, sir. The court will make the following finding in this case that Mr. Brown does have a minimal support obligation of $152 per month, that his last payment was made back in May 27, 2022, is not paid in 2 years, that again, his mother was diagnosed with cancer, and then he was providing her with care. She did pass away back on November 16th, 2023. That since that date, he's not done anything other than when he got up here back in Michigan. It's on May 15th, 2024, where he was getting involved with the Share Center to address multiple issues that he has. Again, his educational issues. He only went through 9th grade, but because he can't read, he didn't do anything in the ensuing years to acquire those abilities to read or get a job or anything of that nature. That states once his mother was diagnosed that he became a meth addict, which, as we can tell, really helped the problem as well. But notwithstanding that, the court will find that he did not exercise a good faith attempt at compliance. He failed or refused to comply, and therefore he is in contempt of court. Is there anything you'd like to say before sentencing, sir?
No, there is not.
Okay. Well, you did have a prior contempt, and the court does note that. Court could sentence you up to 90 days in jail. I'm not going to do that. Going to give you a break, and hopefully when you get out of jail, you can continue to cooperate and all that. And I will tell you, if you don't, that increasingly your sentence is going to get to be more substantial each time. You understand that?
Yes, Your Honor.
Okay. Well, the court's going to do this. The court's going to sentence you to 30 days in jail with credit for 10 days served. Court will allow you to purge yourself of contempt by paying the sum of $1,000, and if you could pay that amount, then you wouldn't have to spend the additional 20 days. Otherwise, you'll spend that 20 days. When you get out, hopefully you continue to work with the Share Center and turn your life around, sir. Okay.
Thank
Good
you.
luck. Good luck to you. Have a good day. You're free to go.
Thank you.
Okay, let's go to your other hearing. For this one, we have both the NCP and the custodian. So, one moment, I have to rename it. Okay, can you hear us, Mr. Bay? Is it Bailing?
Yes, like baling hay, sir.
Okay, we're ready for you.
Okay, thank you.
Mr. Bailing, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, sir.
I advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes, sir.
Are you doing so freely and voluntarily?
Yes, sir.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get to appear without an attorney?
No, sir.
Court will find that Mr. Bailing does freely and voluntarily waive his right to an attorney. Mr. Bailing, I'm going to take some testimony from you and Ms. Plattick, so if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay, Ms. Plattick, you can proceed.
Thank you, Judge. We're here on docket 2014-2980-DM in the matter of Hoig versus Bailing. Mr. Bailing is here for an adjourned show cause hearing. Presently, he is ordered to pay $700.50 each month. That's a current support obligation of $647, $50 ordered on the arrears, and then the $3.50 service and processing fee. This is the 5th show cause in this matter. He's had 1 previous bench warrant and no contempt findings. The last payment in this matter was made on 5/8 of 2024 for $57.57. He did pay that on his own. Compliance was measured over 5 months at the $700.50 per month. During that time, he's paid $1,409.05, which leaves him short $2,093.45 for those 5 months. Current arrearage is $2,681.20, applying anything towards the arrears balance.
Okay, thank you. Mr. Baleen, do you contest or dispute any of the statements made by Ms. Platic?
I believe she is accurate. It's been a little tough catching up with no snow. I do apologize for that.
Okay,
Oh, was he the snow guy? You guys, he was the snow guy. We've heard him before talk about waiting for the snow. I'm sorry, sir. Get a different job. You cannot rely on that, obviously. I'm pretty sure we've listened to this one before, right? Allegedly. I clicked the wrong button there. We're good.
and do you have any questions for Ms. Platic?
I don't. I just I spoke with her earlier and got a price, and I had let her know that we were going to make at least a month within 4 or 5 days.
Okay. What can you tell me? Why have you, again, looks like you've continued to fall behind on your arrearages. Why is that?
Well, I was working for a company for a while that the child support wasn't being taken. It did get paid. I started my own business to try to eliminate this process. And unfortunately, Mother Nature doesn't like us in the winter. So it was very hard to get through. And the April bills for lawn care came through. We did end up paying a little bit as much as we could. And we did, end up paying in Jackson as well, getting some bills caught up. Bills are coming in at the month end. The first of the month, we get all of our money coming in for our lawn care services that we provide. And I'll be able to make a nice chunk as soon as, the 1st of June gets here and we get things caught back up, because we're really rolling on the lawn care right now. We're getting very, very busy, which is going to help everything.
Okay.
Thank you, ma'am. Thanks.
What do you, again, obviously, when there was no snow, you weren't getting snow removal. What do you make on average per month for your lawn care business?
Let me check with the girlfriend secretary here. What would you think?
Oh, fucking bad move, dude. Mama Llama, just getting back from the lake. How would you feel if you were Heather sitting over here, the ex-wife, and he's like, hey, girlfriend, babe, lover, woman who gets more than $57 a month from me? I mean, sir, come on. You should have some fucking class.
Well, say it's about 30.
Well, if you know, sir, just a rough.
I mean, 3,800 to 4,200 a month.
But that's gross.
And that's gross. That's no overhead, gas, things
Okay.
like that.
And do you have employees?
I have one, which I've unfortunately just cut back 2 weeks ago because, certain bills aren't getting made. And unfortunately, you have to take the cut where you have to take the cut. So now I do go out solo. And I'm trying to make an attempt to get all this taken care of.
Sir,
Okay. When was the last full-time work that you had at a not being self-employed?
Oh, I would say it would be late 2022. I worked for FedEx Ground. And I
Hey, go
started
get
my own
another job.
business and took off by myself early of 23.
put him in jail, judge. Put him in jail.
Let me ask you this, if, again, sounds like based on what you said with your growth that are coming in, that they should be sufficient, obviously, to meet your support obligation. And you started that business back in 2023. Why weren't you able to pay in 2023 to the point where you should have?
It was, it's definitely been a building experience. We're getting busier and busier this year, especially. We're up to about 50 lawns a week. So as this was taken off, we have unfortunately the mortgage and the gas bills and all the other stuff that comes in, and we got to make sure that we can.
Yeah, kids are so simple. I love that about kids. They don't actually need to eat. They don't need clothes. They don't need school items. Kids are the one bill that you don't have to pay. Actually, it's super simple. I mean, fuck, wouldn't want to leave the bank short. Wouldn't want to leave your truck short. I mean, he sounds so nonchalant about this. I am getting mad. Heather's sitting there going, "You're fucking lazy ass." Oh, bothers me. I don't think it was mentioned how many kids. I'm thinking more than one. But yeah, of course he's getting paid under the table. 50 lawns a week and they're all being declared. I don't think so. Also, if you mow 50, hold on. Can we just even do 50? How much would that even cost? Who wants to bet the new girlfriend's pregnant?
Have a good home for Parker to come to when he's here, but things are really taking off for the better. This hearing couldn't have happened at a worse time, unfortunately, because like I say, here in the next few days, we are getting ready to make at least a 1-month payment, and we're going to keep doing the monthly payments from here on out, whether it be bi-weekly or if I write a cashier's check once a month straight to the court.
Okay. You understand that Ms. Hogue, she has the same responsibilities you do for mortgage and utilities and all that stuff that she has to pay as well. And she can't do that if you don't pay her support obligation.
Yes, sir.
Okay. Anything else that you'd like to tell me, sir?
I don't think so, sir. Just
Okay.
I'm very grateful for your guys' patience.
Okay.
I fucking hope the judge is not patient. I hope he puts him in jail. Give him a purge amount, judge. Yeah, I was even thinking minimally at $25, but still $50 seems reasonable for a lawn. That's $2,500 a month or $2,500 a week. That's $10,000. She just said 4,000. So what is he talking about?
Things are getting better. I promise you that.
Ms. Hogue, is there anything you'd like to tell me?
Absolutely, if I can.
Go ahead.
Okay. First and foremost, I would like to say he has a boat. He just bought a boat. He's out on the
Oh, girl. Yes. If he bought a fucking boat, send his ass to jail. Send him to jail. Send him to jail. Oh. Look at his face. I would be so livid. I would be so mad.
lake every other weekend. We had to sell our boat so we could afford things like our daughter's dance, all of her extracurriculars. I've been patient with Kevin for years. I've had the kids full time since 2018. I let his custody stay at 50-50 so his child support would be more affordable. All he gives me is the same excuses as to why he can't pay. My husband, whom the kids call dad, works now 70 hours a week for Dish Network. I can provide all the proof that you want, sir. And part of the reason for that is because he has to pay for health insurance on Parker because Parker is ADHD and autistic, and he needs special care. So my husband pays $200 a month for that. That doesn't count co-pays or anything else. My husband has been supporting these kids the whole time since we've been together. Today's his birthday. He's working. Yesterday was our anniversary. He works. He works, because like you said, the bills come in. The kids need food, clothing, shelter, all different kinds of things. Kevin has never, ever been responsible. He does not take the kids like he should. My daughter won't even talk to him anymore. And just in the last 10 months, my husband has spent almost $3,000 towards my daughter's, she's in honors choir. So we travel for that, and for her dance classes, which she loves. So, he wants my kids to have a wonderful childhood. So he works. And
Oh,
unfortunately,
Kevin, do you feel like shit right now? Because you should feel like shit right now. Okay? I don't even think it's a low blow that she just literally told you that your kids call somebody else dad because that guy's taking care of them. She should pound him. I mean, honestly, I don't think the judge is going to pound him. I don't think the judge is going to send him through. So I think that this is what we should be hearing. And you know who should be listening to this the most? Girlfriend, baby, on the other side of the phone. She should be standing there going, "Oh God. Oh my God. Oh, this guy's fucked. Oh, I am stupid. I am so stupid." Because let me tell you something. To me, there is no more of a turnoff than a man who don't take care of his kids. There's a red flag right there. Like, she should be grossed out. And I think that the judge should hold him in contempt. This is willful at this point. If he's actually got a boat and he's out on the boat, no, not cool. Also, Heather, congratulations on finding you a good man. And I am glad for you and the way that you guys are taking care of your kids. I at least am happy about that.
definitely. And for Parker, I have to homeschool him. We were in agreement with Kevin and his girlfriend that they were going to help, but they have not helped at all. I can't work. I have to homeschool him all day long. I'm in my car right now because he's inside on a Zoom. But one of my biggest concerns that I've been stressing to Kevin about is Parker needs behavioral therapy. And in order for him to get the right therapy that he needs, it's going to cost money. We have not met our deductible yet, so it's going to come out of pocket, unfortunately. And this is to get him to have more emotional regulation and be able to control himself, to be in a public setting with other students. This is extremely important. I am looking for a part-time job so I'm able to pay for that therapy because it's $150 a session and he needs 2 sessions a week for the summer. I've stressed to Kevin numerous times that we need help. And sir, he does not help. He actually sent me a text message the other day and asked if I wanted his old boat. Said, it just needs a motor, it needs to be cleaned up. And I'm sitting here thinking, like, we can't even go on a date night. I'm sorry. Because we're taking care of everything and we always have been. And I've been patient with Kevin. I've been understanding. I've been, okay, this business, like, good for you, but it's not working. My husband would love to start his own business. He's a very smart man, but he can't. He has to work because bills come in. He has responsibilities. And like, my husband doesn't have any children of his own. And we can't even save up the money to have a child together of our own because we love the kids, but every single penny, every single thing we have goes to them. And Kevin knows this, and I'm just tired of it. I get no respect. And on top of it all, he makes our lives so hard, sir. He called the CPS and made false accusations. The CPS closed the case because Kevin literally told the CPS worker, you know what, I'm just not even going to take Parker. So just drop it. And you can look that up. But I'm sorry, I'm getting emotional. It's just, I'm tired of the excuses. Your business isn't working, get a job. Get a job. So
Mr. Bailing does have a support obligation of $700 and 50 cents. It's nominal when you consider as yeah. So in this case, the court will note that the respondent in this matter did start his own business back in 2023, that he had supposedly a good job with FedEx prior to that time, but that he quit that to go his own business, that it took some time to develop. He now is doing, as he says, 50 lawns per week. His monthly gross is $3,800 to $4,200 per month. Clearly, court will note that he has sufficient income to pay the support obligation, but he, as he stated, he's paid other things, other expenses of his own, totally disregarding any of the expenses that.
I doubt he's doing 50 a week either. Jim, thank you so much. I'm all riled up. Thank you, thank you, thank you. Do. Thank you so much. Make sure that you guys have gifting on. We do members only on Sundays. I know, I don't think he's doing that. Look at Jim doing it again. Thank you so much. And then here's Jessica, a member for 4 months. Thank you too. You guys rock. Chuck is having a hard time typing. Please keep that in mind, guys. Thank you again, Jessica. Thank you, Jim, and Jim. Seriously, guys, we got to get to 2K. I know. I want to be there. We're so close. We're less than 25 away. But that's freaking true, Bill. That's true. I think it's unacceptable. I'm really hoping that the judge lays down the line. Oh, thank you, Jessica. Yes, I talk. God forbid I talk. Let's see. What do we think? Get your votes in now. Do you think the judge is going to lay down the law, or is he going to let this guy waltz all over him again? These are the questions. I think I want him to lay down the law. I think he won't. That's what I think.
That the plaintiff has in this matter to raise the children. As a result, the court will find that he's not made a good faith attempt at compliance. He's failed or refused to comply.
Okay, so he's not made the good faith effort. Not like Jessica. Jessica's making a great faith effort right now. Thank you. Jessica making a great faith effort. Giving a membership. Thank you. I hope so. We'll see. Let's see. I really hope that he gives him a big purge amount and makes it so like, hey, bud, you want to do your 50 lawns next week? You're going to have to pay this money. Also, the mathing. Right? The mathing when he's saying 50 lawns a week. Can somebody actually figure out how cheap he would have to be doing 50 lawns a week in order to gross $3,800? Because that's low. Right?
And he is in contempt of court. Anything before sentencing, sir?
I would like to be able to make money so that I could pay. I mean, this is all going to change in less than a week.
Okay.
I really do. I hope that I can, continue to make money. Things are going really well.
Yeah. Well, I'm going to give you that opportunity, although the court does have some reservation about that. What I'm going to do, sir, is I'm going to sentence you to 21 days in jail with credit for no time served, but I'm going to allow you to purge yourself of contempt by paying the sum of $1,000 no later than June 14, 2024 at 4:00 p.m. If you don't pay the purge amount by that date, then you'll have to report to the sheriff's department to serve your 21 days in jail. You understand that?
Yes, sir. That will be done.
Okay, good. Anything else, Ms. Platic? Okay, thank you.
No,
You're
thank
free to
you.
go. Have a good day, and hopefully we don't see you back.
You won't. Thank you, sir.
Thank you.
Oh, we will,
Thank you, Judge.
Kevin. Kevin, I think we will. Absolutely. We absolutely will. Allegedly. Heather, I apologize to you. I'm so sorry. But go on a date night with your husband. Please. Hi, Brew Crew. Nice to see you. Long-time listener and watcher. Thanks to Chuck. I love it. I think we'll see him in the month. Also, again, as the girlfriend sitting there, I would feel disgusting. Absolutely disgusting. Listening to that from the ex-wife. I mean, I hope she ain't pregnant, because she better know that he ain't gonna take care of that kid, allegedly. All right, let's see what else is on this docket.
Okay, so now we can get to your record.
You have record?
I do, Judge, just a couple.
Go ahead.
Start with docket 2001-859 DS involving Joshua Brady. In this matter, friend of the court met with Mr. Brady from the Calhoun County Jail, and he waived his right to hearing. He's currently going to be lodged in the jail until September 11th of 2024. So friend of the court is requesting his friend of the court bond be canceled and he be released. The matter be dismissed, and upon his release, he begin paying as ordered $96.50 per month on the arrearage.
Okay. Court would cancel the bond previously ordered for Mr. Brady in this matter. The court would order that upon his release, he would in fact comply with the orders of this court and pay the sum of $96.50 per month on the arrearage. Court will also order that he reports to the front of the court within 14 days of his release from incarceration.
Thank you, Judge.
And then dismiss the action.
So, dockets 2007-140 DS and also 2013-2653 DM, both of those involving Jeffrey Brown. In these two matters, Mr. Brown did fail to appear this morning. However, he has been paying through income withholding and is compliant in both matters. So in lieu of bench warrants, friend of the court's requesting both matters be dismissed and he continue to pay as ordered in June.
Court would order that Mr. Brown would continue to pay as ordered, and will dismiss the actions.
Thank you. Docket 2021-1057 DP and also 2021-1620 DP, both of those involving Darrell Jameson. Friend of the court is requesting both of these matters be dismissed and Mr. Jameson continue to pay as ordered in June.
Court would order that Mr. Jameson would continue to pay as ordered, and will dismiss the actions.
Thank you, Judge. That is all I had for you this morning.
Okay, thank you. Have a good day.
You too.
Get those orders to me as soon as you can too.
Brown is in. I'm gonna do bailing right now.
Okay, thanks.
All right,
Mhm.
perfect. Let's continue.
There are good men out there. There are good women out there too. My daughter's stepmom is a great woman who actually, they just got married. So, but she's great. Very, very, very good. And I think that it's sad for the kids. Like, and he thinks he won. You're right about that, MB. But I'm glad, Mama Llama, that you have found you a good man too. Yeah, damn straight, Chuck, eh?
Good morning, Miss Barrington.
Good morning, Your Honor. How are you today?
Doing well. You?
Oh, quite well as well.
Good. Go ahead when you're ready.
Thank you. A friend of the court spoke with the following respondents this morning, and they waived their right to appear for hearing. Docket 2012-3575-DS involving David Wood. The respondent is making considerable progress towards compliance and has satisfied an agreement with friend of the court for the rescission of his license suspension. Therefore, friend of the court requests that the license suspension be rescinded, that he continued to pay as ordered commencing in June, and that this matter be adjourned to August 28th at 8:45 a.m. to monitor his continued compliance.
Okay, the court would rescind the license suspension in this matter, or that Mr. Wood would continue to comply with the orders of the court, and will adjourn the matter to August 28, 2024 at 8:45 a.m. to monitor his compliance.
Thank you. Docket 2017-1524-DS involving Curtis Hoyt. Friend of the court is requesting that the respondent be ordered to participate in the GEMS program, that he pay as ordered beginning June 1st, 2024, and that this matter be adjourned to July 31st at 8 a.m. to monitor his compliance.
Court would order that Mr. White would participate in the GEMS program, that he would continue to comply with the orders of the court, and will adjourn the matter to July 31, 2024 at 8 o'clock a.m.
Thank you. Docket 2013-217-DS and 2018-1875-DP involving Jason Vasquez. The respondent reported new employment this morning. Therefore, a friend of the court is requesting that the bonds posted in each case be forfeit and applied to the arrears. The respondent repay arrears on the 2018 docket at the rate of $100 per month, that he continued to pay as ordered, and these matters be adjourned to August 28th, 2024 at 8:45 a.m. to monitor his compliance.
Court would order that the bonds previously posted by a respondent would be forfeited in this matter, and order that on the 2018 case that he repay his arrears at a rate of $100 per month, and will adjourn the matter August 28, 2024 at 8:45 a.m. to monitor his continued compliance.
Okay, and the rest of that is boring, I think. So we're going to find a different one because I have so many. Let's see if this one's more exciting. Potatoes. Oh, very, very close face from the judge here. Let's see what he has to say.
One moment, please. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Wednesday, May 29th, 2024 at 8:33 a.m. and this is 2023-2819 DM, Stephanie Martinez versus Ricardo Rodriguez. The defendant is attending via telephone.
Okay. Good morning to both of you. Court will note that this matter is before the court pursuant to the plaintiff's motion for entry of default judgment and a uniform child support order in this particular case. Mr. Rodriguez, are you disputing or contesting anything in this matter?
No.
No? Okay, thank you. Ms. Martinez, we're going to need to take some testimony from you, so if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do. I swear.
Ms. Martinez, do you have the script that we would have provided you?
I do.
You can go through that now, but you don't have to list your address.
My full name is Stephanie Lynn Martinez, and I'm the plaintiff in this case. I married the defendant on the 18th of December, 2021 in the city of Horton, Michigan, located in Calhoun County of the United States of America. I filed a complaint for divorce on the 17th of October, 2023. I lived in Michigan for 180 days and in Calhoun County for 10 days immediately prior to filing this complaint. When I filed my complaint for divorce, all of the statements were true. All of the statements in my complaint for divorce are still true today.
There has been a breakdown of the marriage and relationship such that the objects of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. I do not believe there is any possibility of reconciliation. I am not currently pregnant. The defendant and I have one minor child together. Her name is Ezra Rodriguez, and she is 4 years old. I have read all of the terms of the proposed judgment of divorce, and I agree with them. I would like the court to change my surname to Cole, my maiden name, Cole. I ask that this court grant an absolute judgment of divorce. Thank you, Your Honor.
Thank you, ma'am. Court will find that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. As a result, the court will enter the judgment as submitted and the UCSO as well. In this matter, that will conclude your case. You will be divorced, and best of luck to both of you. Hope everything works out for you. Ms. Martinez, you said that you want to change back to Cole. I don't have the judgment in front of me. I'll look at that in a moment. Just to make sure, what is your middle name?
Lynn, Lyn.
Okay. Okay, I just want to make sure because sometimes people don't include that when they change the name back. They don't include their middle name. I assume you want your middle name?
Yes, sir.
Okay.
Your Honor, thank you.
Okay, I will get into that in here a moment and get that concluded. You're free to go. Have a wonderful day.
Thank you. Thank you, Your Honor.
Let's move on to our next case here.
Divorce quickie.
We're gonna go to the Edwards and Verity scheduling conference. Please unmute both of you.
Unmuted.
Come on.
Good morning.
All right, good, thank you. This is now case 2024-12.
They're in the same house. Hundi P, right? They're in the same house? I'm pretty sure. This is a scheduling conference one? I don't know. They look... That is a weird placement for the wallpaper strip on her... What is her name here? What does that say? Divan? Okay. I used to work with a girl named Davina, which is actually a beautiful name. Davina. She was very beautiful. It does look like a ruler. It looks like those like strips that teachers use in their classrooms. It is certainly an odd perspective of the wall. Like, I think what that would be considered would be like a 3/4 cut, whatever, but still odd, allegedly.
For 6 DC, Devin Edwards versus Rhett Verity. It is Wednesday, May 29, 2024 at 8:37 a.m.
Well, this is the time and place set for the scheduling conference in this matter. And a scheduling conference is whereby the court puts in place a order which will, again, help set various dates in place as well as processes so that as the case goes forward, it'll do so in an orderly fashion. So I guess I'll go to Ms. Edwards first. Ms. Edwards, in this matter, do you believe that there are any disputes in the case?
What does that mean?
Are you fighting about anything?
I don't believe so. We have not had contact in months, so.
Okay. I will ask Mr. Verity. Mr. Verity, is there any disputes that you have in this case as we go forward?
There is no disputes right now, Your Honor.
Okay, I'd like to point out I was wrong. They're not in the same house if they haven't talked. Also, is trailer spelled differently in the States? In Canada, we spell trailer with an E.
Honor.
Okay, so you believe that you have an agreement on custody, support, parenting time?
Yes.
Okay. And Ms. Edwards, do you believe that's correct too?
Yes, I do.
Okay. Well, I'm not going to put in place a scheduling order then, because if I do, what it does is that initiates the mediation process, and there's a cost to doing that. And I don't want you to incur that cost if you don't need to. So what we'll do is, I'll leave that up to you, Miss Edwards, is you're going to need to prepare a few documents. You're going to have to prepare a judgment of custody or a judgment, and a UCSO, which is a Uniform Child Support Order, and a judgment information form. Those three documents you'll have to prepare. And once you get those prepared, you can submit those to the front of the court for their approval. And if they approve those, then you submit them to Mr. Verity, and that way, if he approves them, then we'll be able to get the final judgment entered at that time.
I caught the judgment of custody and the uniform.
Child support order and a judgment information form. And if you forget, you can go back. These are on YouTube, so you can go back and
Okay.
review it at that time and see what else. Anything else that you need, Miss Edwards?
I don't believe so.
Okay, Mr. Verity?
I do not think so.
Okay, thank you. We'll let you go then, and once we get those documents, we'll be able to get the matter completed. So have a good day.
Thank you.
Judge, should we set a status conference to monitor?
Yeah, we'll set it out about 30 days or so. Maybe. Yeah, we'll set it out about 30 to 45 days, and then we'll be able to check in at that time.
Okay,
So
very good.
the papers that you need, I did all of this on MI Legal Help.
Okay.
Are those documents gonna be under the files?
Yes.
Okay. Because I printed out everything, so I have it. I just have to find it.
Yeah, or either that or you didn't get to the end where it said, preparing the judgments or whatever.
Yeah. I will get those taken care of, and most likely turn those in tomorrow.
Okay, well, we appreciate that. You have a good day.
You too. Thank you.
Okay, very good. Let's go on to our next one here. All right. Now we're gonna go to Daniel. Another scheduling conference, and then probably jump right into the PPO arraignment.
Did he say the PPO? Oh, please let it be a PPO.
Hold on. One moment, please. Plaintiff is still connecting there. Okay, let's see. Okay. Ms. Daniel, can you hear us?
Yes, I can hear you.
Okay, all right. Thank you for your patience, both of you. So this is 2024-645 DM Kelsey Daniel versus Edward Daniel. It is Wednesday, May 29th, 2024 at 8:42 a.m.
Is she in a bathroom? Is she in a bathroom stall right now? I'm fairly positive she is in a bathroom stall. What is the clerk's name? I think it's Jesus. God, I hope it is, and that's not just me being totally racist. Yeah, that's a bathroom for sure. Also, I just set this up, but when we finish these, hopefully we'll be finished in before Collins live, and then this will redirect to the live afterwards. It is Jesus. Okay, good. Yeah, geez. Bathroom stall. Oh, Tammy. Well, we'll send good vibes for your hubby. It could be, except you see that one like stall wall over her shoulder. Also, that fan or the grate on top tells me it's like commercial. And to be clear, this is one more scheduling hearing, and then there's a PPO, supposedly.
Good morning to both of you. We're here today for a scheduling conference, and that's where the court puts in place various dates and processes so that the case will proceed in an orderly fashion. First, inquire of the parties. First, Ms. Daniels, do you believe that there's any disputes that you have in this case?
What do you mean by that? Sorry,
Well,
sir.
are you arguing or fighting about anything?
Not really. Just the kids, basically. But
Okay, so there is a dispute concerning custody, parenting time, or support?
I got sole custody right now, temporary sole custody right now, because he had a head injury. So
Okay, let me ask Mr. Daniel. Mr. Daniel, do you believe that there's a dispute on those issues, custody, parenting time, or support?
Yes, sir.
Okay. Well, with the fact that he has stated that there's a dispute, the court will in fact acknowledge that, put that there is a dispute, so we will do a scheduling order. Are there any property disputes?
no.
Okay. Any disputes as it relates to spousal support?
No, sir.
Ma'am?
Kinda.
What?
I said yes. I
There
believe
is?
I should get spousal support. Yes, I believe I should be having
Okay.
spousal support
Well,
because he took care of me
I'm
for
just
many
putting,
years, and I
okay,
finally
but
had to get a
ma'am,
job.
ma'am, I don't need the details. I just need to know if there's a dispute on those items. Okay? When we have a trial on it, that's when we'll address those particular issues.
Okay.
Any other disputes that you can think of, Miss Daniel?
No.
Mr. Edwards? I mean, Mr. Daniel?
No, sir.
Okay. What I'm gonna do is give you some time for discovery, and discovery is the process whereby you can get information from the other side. If you needed income information or other information, you'd be able to get that. So what I'm gonna do is, I don't know if you'll have any, I'm gonna give you to July 1 to do that. So you'll have to move rather quickly if you're going to do that. And so what'll happen, that'll means mediation will be in July. Miss Daniel, is there any mediator that you're aware of that you would recommend?
No.
Okay, Mr. Daniel?
No, sir.
Okay, then the court will the mediation clerk will randomly assign a mediator in this particular matter. I will tell you there is a cost associated with mediation, and it depends on the particular mediator. So I can't tell you what it's going to cost because we simply don't know as to who gets assigned at this particular point. And if in fact you get to a point where you cannot, or you don't believe that you can pay the cost of mediation, then you need to get matters resolved, or you'll have to proceed with the mediation at that point. Okay, anything else that either of you have?
No, Your Honor.
Okay, what I'm gonna do is set up the settlement conference date for August 5th, 2024, at 30 p.m. Parties are required to be present, so you will have to be here at that time. And it'll be just like this. It'll be like by Zoom, and then we'll see where we're at that point as to whether we need to set the matter for trial. So we will send you this case scheduling order. It'll go out today, actually. You should get it yet this week, if not the beginning of next week. It'll have all the dates in it that you need to pay attention to. And because some of those dates, if you don't, it'll have consequences to your case because you could miss the dates for disclosing witnesses or exhibits or things that you might need at trial. So make sure that you pay attention to those dates when you get it. You have any other questions, Miss Daniel?
Yes, so we're not getting a divorce today. The reason why I asked is I'm gonna have a baby any day now, and my boyfriend can't sign that birth certificate.
Nope.
Oh, fuck. You can't even get a divorce when you're pregnant, you dumbass. Oh, my God. Oh, my God. Okay. Oh, my God. If you don't know, remember the last lady who was so prepared, who read out the thing and said, to the best of my knowledge, or I'm not pregnant? You have to declare that during pregnancy. We've also had a case on the channel where the woman lied about her pregnancy status. You saw this live last night? I think it happened today. Rebecca? I feel like it happened today. It is the 20. Was it really yesterday? It might have been. Might have been. Might have been. Yeah, I know we should make it short of this, actually. Then possibly it was from yesterday. Let's see.
You will not get we can't get divorced until we get the matters resolved. So I don't know when that'll be. It depends on when the two of you can come to an agreement, and you may not be. We end up having to have trials. So I can't tell you when we'll get the matter resolved, but that's up to the two of you. And in this matter, I don't know, I don't have it in front of me because I just signed some papers on this. You have a 180-day waiting period from the time that you filed your complaint. So, and I know you're not into that. You're not past that 180 days because we're just doing the scheduling conference. We do that early. So the court legally cannot sign it until after the 180 days.
So what am I supposed to do when the baby's born then? Because it's my boyfriend's baby.
Well, what you're going to have to do, that does add a wrinkle to the thing. You're going to have to file a motion to determine the child was not issue of this marriage and a child born out of wedlock. So you're going to have to file that motion. And then we're going to end up we'll have to do a DNA test as well. And so
we're already getting it done since the baby's born, sir.
Excuse me?
We're already getting it as soon as the baby's born. We're doing it right in the hospital after it comes out.
Okay, well, that's fine.
Yep.
What we'll do is we'll just we'll have that hearing, and then you'll be able to, we'll submit the results at that time.
Okay.
Anything else?
No, Your Honor.
No.
Okay. So, Ms. Daniel, when that does happen, you're going to need to file, once you get the report and that, you'll need to file your motion to determine the child is born out of wedlock.
Okay, so when I get the DNA test back, then I file or whatever.
You can file all that paperwork.
And then he'll be able to sign the birth certificate after that, once everything's like.
After we have the hearing, correct. Okay?
Yes, Your Honor.
Okay, you're free to go. Have a good day.
You too. Stay safe. Bye-bye.
Okay. All right. Just
Yeah, I have to make that into a video. Ma'am, don't appear from the bathroom. You guys, she stood up and the thing flushed, I'm pretty sure. And she looked behind her. When I make it into a video, I will try and enhance it.
we're gonna move right into our arraignment for the PPO. So you have everything in your PPO sign queue, the order after hearing.
I saw it. Just start the hearing.
All right, so let me bring everybody here. I got Jim Jordan for prosecutor.
And she also didn't wash her hands. That's what I was doing this. So wait, this is a PPO arraignment? So he's being charged with violating the PPO?
Just a moment, please. It's Mark Robb Jr., right, sir?
Yeah.
Oh, I'm going to make a guess here. In fact, what's happening. So sometimes when people are charged in different states, if you are charged with a domestic crime, the court system allows for service of a PPO on you while you're incarcerated, and they have to keep somebody incarcerated to a certain time frame. I've heard 4:30, like that next day or whatever, a couple times in court. And so this may be the case where he is being read the specifics of a PPO so that they don't have to worry about service. They can just sort of tack it on to his experience, if you will, his jail experience. Like, if you guys want to go and get a real life jail experience, you can totally do that in Michigan if you don't pay your child support.
Yep.
Yes, sir. Okay. All right. So now this is case 2024 334 PP. Aaron Robinson versus Mark Robb Jr. It is Wednesday, May 29, 2024 at 8:50 a.m. Attorney Jim Jordan for the prosecutor's office.
Okay. Mr. Robb, you are Christopher Robb Jr., is that correct?
Yes, sir.
Mark Christopher Robb, I'm sorry.
Yes, sir.
Okay, you're before the court for
3 first names? That's fucking scary. No offense to anybody else with multiple first names, but Mark Christopher Robb, was that it?
for arraignment on the charge of violating the personal protective order in this particular matter. I'll advise you of the again, the allegations. The allegations are that on or about May 28, 2024, that you did, in fact, enter upon the premises of the petitioner.
I walked down the sidewalk because I had an appointment with the Life Recovery Program to fill out an application for.
Okay, sir, I don't need to hear you.
I did not enter. I did not prowl. I was not
Sir,
stalking.
sir,
I was on
okay,
a
just stop
separate
talking
grounds
until
from-
I get done, okay? You'll have a chance to talk. I'm just advising you of what the allegations are.
Yes, sir.
The allegations are that on May 28, 2024, that you did enter upon the premises at Haven of Rest at 148 East Michigan Avenue, Battle Creek, Michigan, which is the address of the employer of the petitioner, Aaron Robinson, and that you, in fact, remain upon that premises, that you did, in fact, approach her, and that you did, in fact, continue to remain upon that premises, all in violation of the personal protective order.
False.
Entered on February 6, 2024, which is effective through February 6, 2025, by, again, the particulars by approaching petitioner at a public place and then appearing at her workplace as well. You have a right to contest the charges. You have a right to an attorney if you cannot afford an attorney and the court believes it may impose jail time. You have a right to have a court-appointed attorney if you otherwise qualify. You have a right to remain silent and not have that silence used against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to confront witnesses. You have the right to call witnesses in this matter. And you have the right to have the court compel witnesses to appear on your behalf. In this matter, you can plead guilty, not guilty, no contest. How do you wish to plead?
I would plead not guilty.
Okay. And were you looking at having a court-appointed attorney?
Yes, sir.
Okay, we'll get you the form. You'll have to fill out the forms and see if you qualify as far as your income in that to qualify for a court-appointed attorney.
I'm just trying to get better on with my life, sir. I have to get to I'm supposed to, even today, like I'm trying to get to the Life Recovery Program to fill an application. I could care less about all this mumbo jumbo. I will do what I have to follow through with whatever. But still today, I'm trying to get my life on track. I have nothing to do with I don't have any care to see my ex fiance or whatever she is. I have no regard, nothing, no care whatsoever to deal with her. I'm trying to get my life on track for a better
Okay,
life for
well,
myself
none
and
of
purpose.
that helps us today, sir. We're only here to read.
Well, I'm saying, I can't get help today if I'm not released today on a bond or something.
That's true.
I've got property out there that I've still got to handle.
That's true. In this matter, court will need to give you a hearing date. Mr. Flores, do we get a hearing date in this matter?
I do not believe so. One moment, please, let me check.
Your Honor, in the meantime, the people will represent in this matter.
Is it
And
in Ambex?
requesting at least
I don't have it. Is it in Ambex?
Okay,
requesting 14 days adjourn.
I'll do June 14th. That'd be June 14th at 9:30 a.m.
I can do that.
at what time?
9:30 a.m.
Okay,
Oh, do we think he's going to get a PR bond? I personally do not believe that they should give PR bonds on a violation of a PPO. I don't think that's fair. You've been well warned on a PPO about what the facts are, and I am like, the court needs to understand. They should treat violations of their court order extremely seriously and use all of that ability to the most they can. Because believe me, if people got wind that, dude, if you violate a PPO, the judge will throw you in jail for XYZ time. Like, that means more. And he did. He ran his mouth. Can't keep quiet. Don't care about the mumbo jumbo. Good.
okay, Mr. Rob, that's the hearing will be June 14th, 2024 at 9:30 a.m. Do
Yes,
you wish
sir.
to address the issue of bond, Mr. Jordan?
People would ask for $1,000 cash bond on this matter, Your Honor.
Okay, Mr. Rob, do you wish to address the issue of bond?
I would like a personal recognizance bond, and I can pay it as soon as I can pay it on the 1st. Honestly, if I get let go on a PR bond, I can get half of it paid.
Okay, well,
And that's I mean, you guys want me to work and get you your money. I need to be out there to be able to get you your money, and I
Yeah.
can have it on the 1st.
What money? What is he talking about? This is the PPO violation, sir. They don't want your money. They need you to not violate the PPO. What is he thinks the $1,000 bond, right? We ride Sack Rider here quite a bit. It's fun. And yeah, Hector, I guess this was from yesterday. I literally downloaded maybe 30 hearings between yesterday and today, so sorry.
Sitting in here, I'm doing nothing, and I can't do anything.
well, I understand that, sir. Well, what I'm going to do is I am going to propose a bond. I'm not going to do as the prosecutor requests. What I'm going to do, Mr. Rob, I'm going to set your bond in the amount of $200. If you're able to post that bond, you'd be able to be released. Do you have any questions?
I'm not going to be able to post that bond, sir. Like I said, I've got other things that I have to take care of. I've got property I've got to handle, and I could get you, if I was let go on a PR bond, I could have that today or tomorrow. I'm trying to work with you guys. If that's the best you can do, then I guess that's where I'll stand.
That's the best we can do, sir. Anything else, Mr. Jordan?
No, we thank the court.
Okay. That will be the order of the court. Then you'll be remanded as well. Mr. Rob, you'll have to get fingerprinted in this matter. The court will sign that order so that can.
So I'm stuck here until the 14th at least?
You're stuck until the 14th unless you post the bond, correct?
Wow, dude.
And Judge, Mr. Sackrider did join.
I didn't hear anything else. Y'all are all fucked. You don't even know what the fuck is going on out here.
Okay, come back here, Mr. Rob. Mr. Rob, come back here. You don't talk like that and be disrespectful. The court is holding you in contempt.
This is a
of
whole
court.
complete
You're in
disrespectful
contempt of court, sir.
situation.
You will
This is a
serve
personal
3
issue
days
that
in
is
jail.
completely disrespectful beyond all regards.
Keep it up and we can add more time, sir.
Whoa.
Sorry, Mr. Sackrider, didn't know that you were present.
My apologies, Your Honor. I was late this morning. I didn't see the email. It's my understanding he entered a not guilty plea and was given a bond.
Yes, a bond in the amount of $200. And as you might have heard, that the court did hold him in contempt of court and put him in for 3 days, but he's also there until the 14th when we could have that hearing.
What time on the 14th?
9:30 a.m.
All right, thank you.
Okay, thank you. You're free to go. Have a good day.
Thank you.
And just one more thing, Judge, so there's no fingerprints until guilty, so that order will not be.
Yeah. We'll just sign
that needs to be signed.
Yeah.
And will that be in front of you or Judge Yost?
That'll be in front of Judge Yost.
All right, thank you.
Okay, thank you all. Have a good day.
All right, well,
Did you hear him say fuck in the background? I gotta make 2 videos now, at least 2 or 3 videos. I really enjoyed this evening, you guys. It was quite a nice night. Thanks so much for being here. If it was your first time here, welcome. And if it was, your 50,000th, welcome back. I hope that you have a wonderful evening. We are going to be back tomorrow with more. Yeah, keep an eye out for some videos later on. I might even go through some of the other clips that I have and see what we got. I hope that you have a wonderful evening. I have set this video up to redirect to Collins Live, which should be going live in approximately, looking at my wrist that does not have a Fitbit on it, 12 minutes. Make sure that you have a wonderful evening. And remember that I love you. I am proud of you. And I will see you in the next video. Bye.